Good day, dear listeners. It's Lena again, and I am glad you're here. My stepfather died and left everything to his second wife. Or so she said. Then the insurance company mailed a check with my mother's name on it. Stay with me. Because the most important financial document in a marriage isn't always the will. Sometimes it's the one-page form that never got updated. There is a particular kind of paperwork that people avoid, not because it is difficult, most of it takes less than 15 minutes, but because completing it requires them to sit with a fact they would rather hold at arm's length. Updating a beneficiary form means thinking about death. It means choosing, in writing, who gets what when you are gone. It means confronting the arithmetic of love and loss, and whatever version of the future you believe you are building toward. For most people, that confrontation happens once, when the form is first filled out, and then the form goes into a file, and the file goes into a cabinet, and the cabinet stands in a study or a spare room for years or decades, while the life outside it changes in ways the form does not record. Gordon Tolley was a meticulous man. His files were organized. His bills were paid on time. He updated his will after his second marriage. He updated his bank accounts, his vehicle titles, the addresses on record with his financial planner. He did everything a thorough and careful man does when his life changes significantly. And then he left one form untouched in a manila folder, labeled in his own handwriting, filed in a cabinet in the study where Renee had never thought to look. He may not have remembered it was there. Or he may have remembered and found he couldn't quite bring himself to touch it. I don't know which. I stopped wondering. Eventually, the answer doesn't change what the form said. This is the story of Carol Tully. It is, in part, a story about her mother. Carol Tully is 42 years old and works as a paralegal at a civil litigation firm in Richmond, Virginia, the same city where she grew up, in the Carytown neighborhood of wide porches and neighborhood coffee shops and streets shaded by old trees. She came to the law the way some people come to their parents' professions, not quite intentionally, not quite accidentally, in the gradual way that familiarity becomes vocation when you are not watching too closely. Her mother, Margaret, had worked in law. Carol had grown up around legal files and professional documents and the specific patience of people who understand that the record of a thing matters as much as the thing itself. By the time Carol was old enough to choose a direction, the law felt like home in the most basic sense, already furnished with the habits she already had. Margaret Tully died 11 years ago, of an illness that moved faster than anyone expected. She was 60 years old, organized to the end, and she left a small estate and a daughter and a husband named Gordon, who had loved her with the steady, undemonstrative affection of a man who has found the person he intends to spend his life with, and is not required to narrate that fact aloud. Gordon grieved. He kept Margaret's things for a long time before he could bring himself to move them. And then, after a few years, he met Renee, and life moved forward the way life moves forward when it is still happening to you. Carol watched all of this from a respectful distance. She did not resent Renee, or she tried not to. She acknowledged that her stepfather deserved the company of someone who was alive and present, who could sit across from him at dinner and watch television and be part of the daily texture of his life that Carol, in another city, building her own life, could not provide. She asked no questions about the financial arrangements. She did not expect anything from Gordon's estate. She was not that kind of daughter, or stepchild, technically, which is a category that family law acknowledges and everyday experience sometimes complicates. She had her mother's address book and a small framed photograph that Margaret had kept on her own desk. That was enough. What she had that she did not know she had was her name on a form in a manila folder in a filing cabinet in a study that Renee cleared out in the 2 weeks after Gordon's death, leaving a box of documents on the front porch with a handwritten note that said, in Renee's looping script, "These are from your side." I want to tell you about the weeks between Gordon's death and the Sunday morning Carol opened that box, because those weeks describe a particular kind of grief that is also a particular kind of dispossession. The experience of being treated as peripheral at the moment when the household you were once part of is reorganized by someone who believes they have the right to organize it. Gordon died on a Tuesday in early spring, in the house in Richmond where he had lived with Margaret, and then alone, and then with Renee and her 2 adult children who had moved in over the previous 3 years. Carol learned of his death from a text message from Renee's daughter, not from Renee directly, not from a phone call, a message. She drove to Richmond the next morning and found the house already in the process of reorganization, Gordon's study partially cleared, his personal files stacked in the hallway, Renee directing her children with the focused energy of someone who has been waiting to begin. Carol asked whether she could have a few minutes to look through the files. Renee said she had already identified what was Carol's side. Carol said she understood and drove home. The funeral was the following Saturday. Carol attended. She sat in the 3rd row and watched the service from a position that felt, without anyone making it explicit, like a polite acknowledgement that the front rows were for the family Renee had assembled. Carol did not object to this. She accepted the positioning with the professional composure of someone who has learned, in the practice of law, that not every battle is worth the cost of fighting it. She said a few words to Gordon's friends, accepted their condolences, and drove home in the late afternoon light. 3 days later, a box appeared on the front porch of Gordon's house, addressed to Carol in Renee's handwriting. The note was clipped to the flap with a binder clip. "These are from your side." Carol drove to Richmond on a Saturday, put the box in her car, and drove home without opening it. She left it in the corner of her spare room for 3 weeks. She was not avoiding it exactly. She just did not feel the specific readiness required to sit with whatever Gordon had kept from the part of his life that predated Renee. She knew, in the abstract, that the box would contain records of that earlier life. She was not ready for the concrete version of the same knowledge. On a Sunday morning in late spring, with coffee and the particular quiet that Sunday mornings have in apartments where one person lives alone, Carol sat on her floor and opened the box. The contents were organized in the way Gordon organized everything, by category, rubber-banded or paper-clipped, labeled in black marker in the upright, careful print she had known since childhood. Tax files by year. Vehicle registration histories, medical records. And at the bottom right, a manila folder labeled in Gordon's handwriting, insurance, Margaret. Carol lifted the folder out of the box and held it for a moment before opening it. She was not anticipating anything specific. She was simply aware, in the way you become aware of certain moments before they arrive, that what she was holding had weight of some kind that she did not yet understand. She opened it. Inside, a whole life insurance policy, 41 years old, issued by a regional life insurance company when Gordon was 33. The face value, $380,000. The beneficiary designation form attached to the back of the policy, last updated 26 years ago. The year before Margaret's illness was diagnosed, Primary beneficiary, Margaret Elaine Tully. Contingent beneficiary, Carol Ann Tully. Carol read both lines twice. Then she set the folder on the coffee table, drank the rest of her coffee, and called her colleague and friend Arthur Voss at his home number. She said, "I found something. I think I need you to look at it." He said, "Call me first thing Monday." She sat with the folder for the rest of Sunday. She did not read the policy again. She had read it enough. Let me explain what Arthur explained to Carol on Monday morning, because the legal structure of a life insurance beneficiary designation is one of those things that sounds technical until you understand what it actually means, at which point it becomes very simple. Arthur Voss is 55 years old and has been practicing estate and insurance law in Richmond for 27 years. He is the kind of attorney who does not express surprise at documents, who receives new information with the calibrated equanimity of someone who has encountered most categories of fact already and requires only a moment to locate the current one on the map. When Carol described the folder's contents, he listened without interrupting. When she finished, he said, "All right. I need to see the policy in the designation form before I say anything definitive. Bring them Monday morning." She brought them Monday morning. Arthur reviewed both documents for 11 minutes, then looked up. "A life insurance beneficiary designation," he explained, "is a contractual instrument. It is separate from a will, separate from the probate estate, and separate from any claims that a surviving spouse might make under marital property law. When you name a beneficiary on a life insurance policy, you are making a contractual arrangement with the insurance company. If I die, pay this person. That arrangement is binding on the insurance company regardless of what your will says, regardless of what your family expects, and regardless of what your current spouse believes. The only way to change a beneficiary designation is to submit a new beneficiary designation form. Gordon had never done that. The primary beneficiary, Margaret Elaine Tully, had predeceased Gordon by 11 years. Under the policy's express terms and under Virginia law governing insurance contracts, when a named primary beneficiary predeceases the insured, the proceeds pass to the named contingent beneficiary. The contingent beneficiary line read, Carol Ann Tully. Arthur said, "I want you to understand what this means. The $380,000 does not pass through Gordon's estate. It does not go to Renee. It is paid directly by the insurance company to the named contingent beneficiary. That is you. This is your check." Carol looked at him for a moment. She said, "Does Renee know about this policy?" Arthur said, "Based on what you've described, I would say no. But she will soon." He was right. Within the same week, Renee filed a claim with a life insurance company, asserting that as Gordon's surviving spouse, she was the rightful beneficiary. Her attorney argued, in the claim documentation, that Gordon had clearly intended to provide for his current wife, that the failure to update the form was a clerical oversight that equity required the company to correct, and that a $380,000 payment to a stepdaughter who was not part of Gordon's daily life was contrary to any reasonable construction of his intent. Arthur received notification of the competing claim on a Thursday. He called Carol to let her know. She was in the middle of a deposition at her own firm and called him back that evening. He described the claim and its arguments. There was a pause on the line. Then, Carol said, "He updated everything else." Arthur said, "I know." She said, "He updated his will, his bank accounts, the car titles. He just didn't update that form." Arthur said, "That's correct." Carol said, "Was that an accident?" Arthur said, "Carol, it doesn't matter. Let me tell you why." Renee's claim came back to a single argument that Gordon's intent should govern. He had intended to provide for Renee. He had demonstrated that intent by updating every other document in his estate after the second marriage. The failure to update the insurance form was inadvertent, not deliberate, and equity required the court to look past the form to what Gordon would have wanted. Arthur's counterargument was elegant in its simplicity. Beneficiary designations are contractual, not testamentary. They are not subject to equitable interpretation based on inferred intent. The Virginia Supreme Court had addressed this question directly in a 2009 case involving a similar factual pattern, and the holding was clear. Absent fraud, incapacity, or a specific statutory override, a beneficiary designation form controls the distribution of life insurance proceeds regardless of the insured's subsequent relationships, subsequent testamentary instruments, or any testimony about subjective intent. Gordon had signed the Form 20 6 years ago. He had never revoked or amended it. The form was valid. The contingent beneficiary was Carol. Arthur filed the counter-argument with both the insurance company's Beneficiary Services Division and in Richmond Circuit Court, where Renee had simultaneously filed a civil complaint. Diane Choi, the insurance company's beneficiary services specialist, reviewed the competing claims and confirmed in writing that under the policy's terms and applicable Virginia law, the contingent beneficiary designation was controlling. The company would not release the funds until the court resolved the dispute, but Choi's confirmation was a significant signal about how the company understood the policy's legal status. The circuit court proceedings moved through the fall and into early winter. Renee's attorney requested Gordon's financial records to demonstrate his intent to provide for Renee. Arthur agreed to the discovery. The records were thorough, Gordon was a meticulous man, and they confirmed exactly what Carol had said. Gordon had updated his will naming Renee as primary beneficiary of his probate estate. He had updated his bank accounts to reflect joint ownership with Renee. He had updated his vehicle titles. He had updated the beneficiary designations on 2 smaller retirement accounts. He had not updated the life insurance policy. Arthur presented these records at the circuit court hearing. He did not argue that Gordon's failure to update the insurance form was intentional. He did not need to. He argued simply that the failure to update the form meant the form had not been updated, and the form as it stood was legally controlling. Renee's attorney called witnesses. Gordon's financial planner, a careful man who had worked with Gordon for 15 years, testified that Gordon had discussed providing for Renee and had taken numerous steps to do so. Gordon's accountant offered similar testimony. Both were credible witnesses. Neither could testify that Gordon had been aware of the specific insurance policy and had specifically decided not to update it. They could only testify that he had spoken about providing for Renee and that he generally updated his financial documents after the remarriage. The judge listened to the testimony. She read the policy. She read the beneficiary designation form. She read Arthur's brief and Renee's attorney's brief. And then, in the way that judges do when the law is clear and their task is to apply it, she read the policy language aloud into the record. The beneficiary designation form is the controlling instrument for distribution of proceeds upon the death of the insured. The primary beneficiary, Margaret Elaine Tully, predeceased the insured. Proceeds shall be paid to the named contingent beneficiary. The named contingent beneficiary is Carol Ann Tully. She looked up from the policy and said, "The motion is granted. The proceeds of $380,000 shall be released to Carol Ann Tully." Renee looked at her attorney. Her attorney did not look back. Carol was not in the courtroom. She had talked with Arthur about attending, and he had told her she did not need to be present, that the legal arguments would be made on paper and by counsel, and that her physical presence was neither required nor necessarily helpful. She had agreed, more easily than he expected, and had spent the morning at her office, reviewing a brief for one of her firm's clients, doing the work of the day. Arthur called her from the courthouse steps. He said, "It's done." The judge granted the motion. Carol said, "Okay." Arthur said, "The check will come in the next few weeks." Carol said, "Thank you, Arthur." She paused. "He kept good files." Arthur said, "He did. Your mother must have kept good files too. You knew where to look." Carol said, "She kept everything." The check arrived 6 weeks after the judgment. It came by certified mail to Carol's Richmond address, a cashier's check from the insurance company, made out to Carol Ann Tully in the amount of $380,000. She went to the bank on a Saturday morning and deposited it at the teller window. The teller verified the check, confirmed the account number, and said, "That's a significant deposit." Carol said, "Yes." She did not explain further. She called Arthur afterward from the parking lot. He asked if she was all right. She said she was. He said the file was closed on his end. She thanked him again. She sat in her car in the bank parking lot for a few minutes with a deposit receipt in her hand, looking at the number on the slip. Then she drove to the Carytown coffee shop where she used to go with her mother on Sunday mornings. And she ordered a cup of coffee, and she sat at the window table watching the street. I want to tell you something about what Carol did with the beneficiary designation form. She did not discard it after the proceedings concluded. She took it from Arthur's file at the closing meeting he offered it, understanding that this was a document she might want to keep. And she put it in a new manila folder. Not the same manila folder Gordon had kept it in, not labeled in someone else's handwriting. Her own folder, blank on the tab, filed in the small filing cabinet in her home office, where she keeps her own important documents. She knows what's inside. She does not need to read it again. But she keeps it because a document like that, a form that sat untouched in a cabinet for 26 years, while the life around it changed in every other respect, represents something that she thinks about often in her work as a paralegal. She reviews estate documents regularly. She sees the forms that people have not updated, the beneficiary designations that name ex-spouses or deceased parents, the insurance policies that predate divorces and remarriages and children who were born after the form was last signed. She sees the gap between people's intentions and their paperwork, and she understands, from personal experience, what that gap can mean. She has become, in the 3 years since the judgment, the person at her firm who asks clients, gently but persistently, about their beneficiary designations. She does not moralize. She does not lecture. She simply asks, "When did you last update this form?" And she waits for the pause that follows, the pause that means the person is trying to remember, and if the pause goes on too long, she says, "Let's take 15 minutes and review it now." Her colleagues noticed this habit and asked about it. She told them, briefly, that she had encountered a case where a beneficiary form from decades past had governed a significant asset distribution. They understood, in the way that lawyers understand case experience, and some of them adopted the same habit. She thinks about Gordon sometimes. She thinks about him in the study with his meticulous files, knowing about the policy or not knowing, updating everything he could bring himself to update, and leaving the one folder that was labeled with her mother's name exactly as it was. She does not know what he intended. She has made her peace with not knowing. He was a thorough man who left a gap in his thoroughness in the place where his first marriage was recorded, and that gap, when it was found, said her mother's name and then her own. She thinks her mother would have been organized enough to find it herself. Margaret kept everything. It was her daughter who opened the box. Let me tell you what this story is really about, dear listeners. It is not about a stepdaughter getting lucky. It is not about a widow being cheated. It is about the specific and binding nature of paperwork that most of us sign once and never think about again. The beneficiary forms, the insurance designations, the contingent beneficiary lines that seem like administrative details at the time, and become, in the right circumstances, the most important document you own. Gordon Tully was a careful man. He updated almost everything. He did not update one form, and that form, signed by a careful man in a different life, naming a woman who had since died and a stepdaughter he may or may not have been thinking about, controlled the distribution of $380,000 with the absolute authority of a contract that had never been revoked. The form did not care about Gordon's current intentions. It did not care about Renee's grief or her expectation or the life she and Gordon had built together. It cared only about what it said, and what it said was the last thing Gordon had written on it, 26 years before he died. Check your beneficiary designations, every life insurance policy, every retirement account, every instrument that names a beneficiary. Review them after a marriage, after a divorce, after a death, after any change in your life that changes the person you would want to receive those funds. Because the form does not update itself. And the form is a contract, and contracts, unlike intentions, have the patience to wait. Thank you for listening. Leave your city in the comments. I love knowing where you are. If this story made you think of someone, please share it with them. Like this episode if it stayed with you. I will see you next time. Let me go back, because there are parts of Carol's life before the box that deserve more space than I have given them. Carol grew up in Carytown in the particular way of children who belong to a neighborhood, knowing the bakery owners by name, cutting through the alley behind the bookshop as a shortcut, understanding the rhythm of the streets at different hours and seasons. Her mother, Margaret, was a presence in that neighborhood in the way that some people are a presence, not loudly, but consistently, in the way that regulars at the coffee shop and familiar faces at the library are a presence. People knew her as the woman from the law office on Elwood Avenue, the one with the auburn-haired daughter who came to pick her up sometimes on Friday afternoons. Margaret had worked in law for 30 years, in the patient and unglamorous way of paralegals who do the essential infrastructure of the profession, drafting, filing, organizing, reviewing, without the court time or the public profile. She was good at it in the specific way that some people are good at things that require care over brilliance, methodically, reliably, with an attention to detail that her colleagues noticed and depended upon. She kept good files. Her colleagues said this at the funeral. Her daughter had heard it her whole life. Gordon came into Margaret's life when Carol was 11, and he became her stepfather with the particular gentleness of a man who understands he is stepping into a space that someone else has already shaped. He never tried to be Margaret's first husband. He never pretended to be more to Carol than the person her mother had chosen. He was present, consistent, quiet in his affections, and he built a household with Margaret that Carol has always understood, in retrospect, as genuinely happy, the kind of happiness that does not announce itself because it does not need to. When Margaret was diagnosed, Carol was 28 and living in an apartment near her firm in Richmond's Van District. She moved back to the Carytown house for the last 8 months of her mother's life, not out of obligation, but because she could not imagine being anywhere else during the specific time, when being somewhere else would be the wrong choice. She watched Gordon during those 8 months with the attention of someone filing away a fact. This man loves her entirely. He sat with Margaret in the hours when sitting was all there was to do. He read to her in the afternoons. He did not pretend things were other than they were, and he did not collapse under the weight of how they were. Carol has thought about that many times since, what it costs a person to be present in that way, and what it reveals about the quality of the love that makes it possible. After the funeral, Carol went back to her apartment and her work. Gordon stayed in the Carytown house. They had a relationship of telephone calls and occasional dinners, the Sunday roast in November, a birthday in March. That was cordial and warm, and did not require them to be in each other's daily lives to remain meaningful. Gordon did not talk much about Margaret in Carol's presence. He did not talk much about anything at length. He expressed his affections the way he always had, by being reliable, by following through on what he said he would do, by continuing to exist in Carol's life in the steady, undramatic way of people who are simply there. And then he met Renee, and the steady, undramatic way of things shifted. Carol does not like to speak badly of Renee. She has tried, in the years since the settlement, to develop a version of the story that does not require Renee to be a villain, because Renee was not exactly a villain. She was a woman who had married a man she cared about, who had organized her life around the assumption that his estate would provide for her retirement, and who found herself. After Gordon's death, facing a document she had not known about that directed a significant asset away from her. Her anger and her legal challenge were predictable. They were, in their way, understandable, what Carol has found harder to forgive, if forgive is the right word, and she is not sure it is the box on the porch. The deliberate act of sorting, labeling, and excluding. The handwritten note that said, "These are from your side," as though Carol's side were a territory that required delineation. Gordon had been part of Carol's life for 30 years. Her mother had built a home with him. The things in that home included things from Carol's childhood, from Margaret's professional life, from the years before Renee arrived. The sorting of those things into Carol's side and what was left was an act of categorization that required a decision, a deliberate decision about what Carol was entitled to know about. Renee had decided. She had left the box. But she had left the box. And the box contained the folder, and the folder contained the form. Carol has thought about that many times. The small decisive act that Renee performed, clearing the study quickly, deciding what was from Carol's side, assembling the box, was performed in the belief that it would consolidate the estate in Renee's favor. Instead, it placed a 30-year-old life insurance file in Carol's hands on a Sunday morning in late spring. If Renee had kept the study closed, if she had locked the filing cabinet, if she had taken longer to organize the papers, Carol might never have found the folder. The insurance company might eventually have reached out through estate proceedings. Or it might not have, and the policy might have expired unclaimed, as thousands of such policies do. Instead, Renee made the box, and the box came to Carol, and Carol opened it on a Sunday morning with coffee. Arthur says this is one of the stranger ironies he has encountered in his practice, that the person whose actions most directly led to Carol receiving the check was Renee herself. He said it without pleasure, as a professional observation about how things sometimes unfold. Carol said, "I've thought about that." Arthur said, "What do you think?" She said, "I think her efficiency worked against her." He said, "That's one way to put it." I want to talk about Renee's phone call, because it is part of the story, and because what Carol did with it matters. Renee called Carol on a Tuesday evening, 2 weeks after the insurance company had received both of their claims. She was not gentle in her approach. She said what she believed with the directness of someone who has convinced herself that the directness is a form of fairness. Gordon had loved Carol's mother once, and that was over, and the idea of money going to Carol because of a form that referenced a dead woman was an insult to the life she and Gordon had built together. She said, "That doesn't mean she gets to reach back from the grave and take what's mine." The phrase "reach back from the grave" was precise and was intended to wound. Carol was sitting at her kitchen table when the call came. She had Arthur's preliminary analysis in a folder in front of her and the original policy in its sleeve beside it. She listened to Renee say what she had to say. She thought about responding. She decided against it. She said, "Good night, Renee," and she ended the call. She has not spoken to Renee since. She did not tell Arthur about the call in detail. She mentioned that it had happened, and that she had ended it without engaging. Arthur said, "Good." That was the end of the discussion. Whatever Carol felt about the call, whatever it cost her to sit with the phrase "reach back from the grave" and say nothing, she kept to herself, in the professional way of people who understand that the legal proceedings are not the place to express it, and that expressing it elsewhere would only be a service to her own worst feelings. What she thought about in the days after the call was her mother. Not in a sentimental way. Carol is not generally sentimental about grief, having processed most of it in the ordinary working way that time and continued living requires. She thought about her mother specifically as a professional, as a paralegal who understood the weight of documents and the finality of signed instruments. Margaret would have read the beneficiary form the same way Arthur read it. She would have said, "The form controls." She would have said this without drama. It would have been, to her, simply a statement of how the law worked. That would have been enough for her. It was enough for Carol. Let me tell you about the procedural period in more detail, because the months between Arthur's initial call and the circuit court hearing were months Carol lived and worked through in the ordinary way, going to her firm each day, reviewing documents, drafting briefs for her colleagues' cases, while simultaneously being the subject of a legal proceeding that required her to be patient in a way that was, at times, difficult. The insurance company's review process was careful and unhurried. Diane Choi, the beneficiary services specialist assigned to the case, contacted both claimants within a week of receiving the competing claims. She was, in Carol's experience of her, precise in her professional communications and genuinely sympathetic in her manner, a combination that Arthur said was unusual and worth appreciating. She explained the process clearly. The company would not release funds while competing claims were unresolved. They would cooperate with any court proceedings that sought to determine the rightful beneficiary. They would hold the funds in escrow until directed by a court of competent jurisdiction. Arthur found Choi's written confirmation useful, not because it resolved anything, But because her language made clear that the company understood the policy's terms and was not inclined to produce creative interpretations in Renee's favor, Choi wrote, "The named contingent beneficiary is Carol Ann Tully. The form has not been amended or revoked. Proceedings to resolve the competing claim are appropriate for circuit court jurisdiction." Arthur filed the circuit court complaint in late summer. The proceedings moved on the standard timeline of civil litigation: pleadings, discovery requests, responses, scheduling orders. Carol attended each stage as a professional observer as much as a party. She understood the documents. She understood the motions. She understood what each filing meant and what it was intended to accomplish. And she watched Arthur work with the specific appreciation of a paralegal who recognizes good lawyering when she sees it: organized, economical, grounded in the applicable authority without unnecessary ornamentation. The discovery phase produced the financial records that Arthur had anticipated: Gordon's updated will, the bank account changes, the vehicle titles, the retirement account beneficiary updates. All of it confirmed what Carol already knew. Gordon had been thorough in his updating after the remarriage. He had missed one document. Renee's attorney presented this as evidence of intent. Surely a man who updated everything would have updated the insurance form if he had intended to omit Renee. Arthur presented the same evidence as evidence of omission. A man who had updated everything had, in fact, failed to update the insurance form, and the insurance form as it stood was therefore controlling. Both arguments were coherent. Both described the same facts in ways that supported different conclusions. The question was which the court would accept. And the answer to that question was not about the facts at all. It was about the law. And the law, as Arthur had told Carol from the beginning, was not ambiguous on the question of whether a beneficiary designation could be overridden by inferred intent. Renee's attorney knew this. Arthur knew this. The hearing, when it came, had the quality of a proceeding whose outcome was not in real doubt, where the legal question had been resolved in advance and the proceeding itself was the formal acknowledgement of that resolution. The witnesses testified. The exhibits were entered. The judge read the policy language, which said what it said, and applied it to the facts, which were what they were. Arthur called Carol from the courthouse steps on a cold November morning. She was at her desk, which was covered in the brief she had been working on all week for a colleague's civil matter, a straightforward contract dispute that had nothing to do with her own situation. She answered on the second ring. "It's done," Arthur said. The judge granted the motion. Carol set down her pen. "Okay," she said. "The check will come in about 6 weeks," he said. "Certified mail." "All right. Are you all right?" She thought about the question. She said, "Yes, I think so." "Thank you for everything, Arthur. Your mother kept good records," he said. "You knew where to look. She kept everything," Carol said. "She always did." She went back to the brief. It was a good brief, and it needed finishing. She finished it by 4 in the afternoon and sent it to her colleague. Then she went home and made dinner and watched the news and went to bed at the same hour she always did. The check came on a Tuesday in early January, 6 weeks and 2 days after the judgment. It arrived in a standard certified mail envelope, the kind with the green return receipt card, and Carol had to sign for it. She signed on the kitchen counter, tore open the envelope carefully, and looked at the cashier's check for a long time before folding it back into the envelope. She went to the bank on Saturday. The teller was professional and thorough. She counted the check, confirmed Carol's account information, and said, That's a significant deposit. Carol said, yes. The teller completed the deposit without further comment, which Carol appreciated. She sat in her car in the bank parking lot afterward. She had been aware, going into the bank, that she was about to do something that felt larger than the act itself, that the deposit was not just a transaction but a conclusion, the closing of a proceeding that had occupied 8 months of her life, and a question that had been open since the morning she first read the beneficiary form. She did not feel triumphant. She felt, more accurately, resolved, the way you feel at the end of a long piece of work when the work has come out right. She drove to the Carytown coffee shop. She ordered a medium coffee and sat at the window table and watched the Saturday morning street, the neighbors walking dogs, the families heading to the farmer's market 2 blocks over, the particular weekend quality of the neighborhood that she had known since childhood. She thought about her mother at the desk in the law firm, at the kitchen table in the Carytown house, in the chair by the window in the last months of her illness, organizing papers with the habitual care that was simply the way she did things. She thought about Gordon in the study with the filing cabinet, the manila folder with Margaret's name, the form inside with the 2 lines he had last touched 26 years ago. She thought he kept her name there, in the folder, in the cabinet, in the form. Whatever he had intended or not intended, whatever he had remembered or not remembered, the name was there, in his handwriting on the folder tab and in the typed print of the form, Margaret Elaine Tully. And below it, in the same print, Carol Ann Tully. She has not decided what she thinks that means. She is not sure it needs to mean anything beyond what it says. Let me tell you about what the $380,000 represents to Carol. Not in terms of what she did with it. She has invested most of it and kept some available, but in terms of what it is. It is the proceeds of a 41-year-old insurance policy that Gordon took out in the year before he and Margaret got serious, when he was 33 years old, and beginning to think about the kind of future he wanted to build. At the time, he designated Margaret as the primary beneficiary and Carol, who was 11 years old at the time, as the contingent. He was thinking about the people who mattered to him and the specific configuration of care that a life insurance policy requires you to name. He was thinking, if Margaret is gone, then Carol should have this. He may not have been thinking that 26 years later. He may have forgotten he had written it. He may have remembered and been unable to face the act of erasing his first wife's name from the document. He may have had reasons that Carol will never know because he is gone and cannot explain them. What is true is that he wrote it once, and it held. Carol has the form in the new manila folder in her filing cabinet. She has her own beneficiary forms in the same cabinet, reviewed last spring for the first time in several years, updated where updating was needed. She also, at the last update, added a note to her own file, review annually. She intends to. There is something I want to say about the nature of beneficiary designations more broadly, because Carol has thought about this professionally in the years since her case, and because I think it illuminates something important that the form itself cannot tell you. A beneficiary designation is, at its heart, an act of imagination. When you fill out the form, when you write a name in the primary beneficiary line and a name in the contingent line, you are imagining a future. You are imagining the person you love, and the person you would want to protect in the event that the first person is already gone, and you are committing those imaginations to paper in a way that the insurance company will honor. The form asks you, in the clinical language of insurance, to articulate what you hope will happen when you are no longer able to speak for yourself. Most people do this once. They do it when the policy is new and the relationships are fresh, and the future feels ordered in the way that futures feel ordered when you are in your 30s and the life in front of you seems coherent. And then the form goes into the file, and the file goes into the cabinet, and the future arrives in the particular disordered way that futures actually arrive. With deaths and divorces and new relationships and children born and moved away, and marriages that end and marriages that begin, and the form, which was once an accurate picture of what you intended, becomes a picture of what you intended in a year you can barely remember. Gordon's form was a picture of 1998. It named a woman he loved in 1998 and a stepdaughter he had known for 15 years in 1998, and in that year it was an accurate expression of his intentions for those specific people. What happened in the subsequent 26 years, Renee, the new household, the updated will and accounts and titles, did not reach back and correct the picture. The picture stayed as it was. It could only be changed by the specific act of changing the form, and Gordon, for whatever reason, did not perform that act. Carol has come to understand this not as negligence exactly, and not as intention exactly, but as the specific failure that belongs to paperwork that is associated with loss. The folder was labeled Insurance, Margaret, to open the folder, to review the form, to take the deliberate action of updating the beneficiary line. That would have required Gordon to sit with the folder that had Margaret's name on it and make a choice about it. And Gordon, who had updated everything else, had not been able to make that choice, or had not remembered he needed to, or had opened the folder once and set it back in the cabinet and told himself he would do it later. Later arrived 26 years after the folder was first labeled. Carol does not judge Gordon for this. She has been a paralegal for long enough to know that the most common reason important documents go unreviewed is not malice or strategy, but the ordinary human difficulty of doing the thing that requires sitting with something uncomfortable. The insurance form required Gordon to sit with Margaret's name in an administrative context, to treat the name as a data point requiring action, rather than as a fact of love requiring only continued holding. That distinction is small. It is almost nothing. And it is, in this case, everything. She has talked about this in her quiet way at the firm, not as a story about herself, but as a professional observation about what beneficiary reviews can surface. She has sat with clients who are updating their estate plans and asked them, "Do you have any life insurance policies you haven't looked at recently?" And when they say yes, she asks, "When did you last review the beneficiary designations?" And, if the pause is long enough, she opens the next section of the checklist and begins there. Her colleagues have noticed. One of them, a senior associate who has known Carol for 8 years, told her recently that she had reviewed her own policies after watching Carol's habit develop. She found 2 policies she had forgotten about, smaller ones from early in her career, with beneficiary designations naming an ex-husband. She updated them the same week. She thanked Carol without explaining how she had come to review the policies. Carol thanked her and moved on to the next file. This is the ordinary way that experience transfers, not in dramatic moments, but in the specific habits of careful people who have learned firsthand that forms matter, that the date on the form matters, that the name on the contingent beneficiary line, the small secondary line that most people fill in without much thought, can become, when circumstances arrange themselves in the way that circumstances sometimes do, the most significant thing a person ever wrote. Gordon Tully wrote Carol Ann Tully on that line in 1998. It is possible that he did not think about it for 26 years. It is also possible that the folder's label, Margaret's name in his own handwriting, was its own kind of memory, sitting in the cabinet where he could have reached it at any time, but never quite did. Carol does not know. She keeps the form in her own file and does not speculate too long about what Gordon was thinking when he made the label, or when he looked at it, or when he didn't. She knows what the form says. She knows what it meant for the $380,000. She knows what the judge said when she read the policy language aloud. That is, she has found. Enough. The coffee shop on Carytown is still there. Carol goes on Saturday mornings when she is in the neighborhood, which is less often than she once did, her own life having relocated slightly further east. But she goes. She orders the medium coffee and sits at the window table and watches the street, which is the same street it has always been, with the same families and the different dogs and the changing seasons that cycle through the Carytown neighborhood the way they always have. Her mother's face is not in the window. Gordon's study is not visible from the coffee shop. But she goes, and she sits, and she drinks the coffee, and she thinks about whatever she is thinking about. Usually she is thinking about work. Sometimes she is thinking about the form. She thinks her mother would have read it correctly, immediately, and known exactly what it meant. She would have made a call on a Sunday morning and gotten the same answer from the same kind of attorney. And she would have been organized about it, and she would have kept the receipt. She would have kept everything. She always did,